Hello, all. Welcome to another session of Legal Essentials for Human Resource Management. Now, this is week 5, a week that we are dedicating for discussions on social security and well being provisions. And this is session 24, where we are going to discuss about the Maternity Benefit Act of 1961. So, without wasting much time, let's get into our discussion on Maternity Benefit Act. I'm Dr. Amish Samalopanan and I'm from Nalsa University of Law, Hyderabad. Now that you have a fair understanding of Employee Compensation Act as well as ESI Act, which we have covered in the past sessions, let's look into history and the background of Maternity Benefit Act. Now, for the first time, this act was introduced in Bombay Legislative Council with an intention to protect the women workers in Bombay's textile industry. So that is the origin of this act. It was introduced as a maternity benefit bill in 1929, even before independence, in the Bombay Legislative Council. The objective of that act was to regulate employment of women in certain establishments for a certain period before and after childbirth. Now, please understand, this is a very important position. From the beginning itself, this act was decided in such a way that the employment of women can be regulated in a period before and after childbirth. And that the act was intending to provide for maternity benefit and certain other benefits. Now, in 1961, the act came into being. But I think the major turning point, or what we will be discussing more today, is about the amendment on the act that happened in 2017. So, a lot of things have changed since 2017 amendment. Before the increased period of maternity leave, now it is 26 weeks from the original 12 weeks. A lot of provisions regarding rights of adoption and commissioning mothers got included in this act. Provisions for work from home are also mentioned in that act. Certain provisions to provide creche facilities in establishment is also mentioned in the act. So we'll see this act in a little detail and understand various provisions covered under this act. But first, let's see where is this act applicable. First, every factory, mine or plantation, including factories, mines and plantation belonging to the government, it is applicable. Establishment where persons are employed for the exhibition of equestrian, acrobatic and other performance. I think the real applicability, this portion is what you should remember. Every shops and establishment employing 10 or more employees on a day of presiding 12 months. So you have seen this sentence framing even before also. Most of the time in labor law, whenever you have a limit in terms of number of employees or workers, it's not just that on the day of the exercise how many employees are there. No, you often have a larger time window that is given to determine the number of employees. So in the last 12 months, if you have employed 10 or more people, so that becomes an eligibility criteria, or any other shops and establishment that gets notified by the appropriate government. The whole idea is that if you are not covered under Employee State Insurance Act, you are covered under the MB Act. As simple as that. And a lot of provisions over and beyond MB Act, State Insurance Act also. Now, regarding the applicability of MB Act, there are certain judicial precedents also. For example, Dr. Rajna Chaurasia versus State of Uttar Pradesh and also others, The court observed that the maternity benefits, including maternity leave, are a type of social insurance. Please to understand how court have interpreted this act. So the court have interpreted these benefits, including leave, as a type of social insurance that promotes maternal and child health while also assisting the families. So perception until this clarity came in was that maternity benefit act is provided to in a way so that the mother who is carrying gets some relief. But the court clarifies it's just not the provision. It's not just to provide a relief for the mother who is carrying, but this is also to take care of scenarios where this mother was a sole breadwinner of the family, and there were a lot of dependents who were looking forward to this mother's salary. So it's not just to assist the mother, but it is also to assist the family which are dependent on the mother. So maternity leave should be provided to all female employees regardless of nature of employment. So that's a very clear legal position that is there. Doesn't matter you are a permanent employee, temporary, ad hoc, contractual, doesn't matter. If they are eligible under the conditions of MB Act, which we will discuss in the next slide, they have to be given all the benefits ensured by the Act. Then another case, state of Himachal Pradesh and others versus Sita Devi. The High Court of Himachal Pradesh reiterated that maternity leave is a fundamental human right and that it applies to every woman irrespective of her employment status. There's always this argument that MB Act covers only women who are in fixed term employment, but the court position is completely against that popular notion. Now, there are certain definitions you should be aware to understand this act completely. So, they are defined in section 3. So, there is a term coined called as commissioning mother. Now, commissioning mother means a biological mother who uses her egg to create an embryo to implant it on any other woman. That is a commissioning mother. So after the amendments of 2017, this act scope of the act has been extended to a lot of categories which before were gray areas of the MB Act. So you are a mother who decided to have a child by using your eggs, but you are planting it on any other woman. So you will be called as a commissioning mother. This act defines wage also. So different act often defines wage in different criteria, and in the wage week we had defined wage as basic plus DA plus RA, which is retaining allowance. But this act has a little more different definition of wage. In this act, wage means all remuneration paid or payable in cash to the woman and include all such cash allowances, including DA, housing rent allowance, all allowances the woman was entitled to at the time when her maternity leave starts. Any incentive bonus is there, that also has to be provided. Money value of the concessional supply of food grains and other articles. If you had given certain food grains or any other thing in a concessional rate, or you had a food coupon, Sodexo coupon, or any other coupon that was given to the employee at the time of her pregnancy or maternity, has to be given to her continuously. You cannot just say कि wage is just basic plus DA. And contribution to PF, So whatever that was being paid to the employee, that has to be continued to be paid at the time of paternity also. This act also defines the term woman. Now, woman means a woman employed whether directly or through an agency for wages in an establishment. So that's the definition of woman in this act. Now let's look at the eligibility criteria for you to be covered under this act. What are the various eligibility criteria? So a woman is eligible for maternity benefits under the MB Act if she is employed in an establishment for not less than 80 days, 80 continuous days in the 12 months, immediately preceding the expected delivery of the woman. So it's defined in section 5.2. So the whole idea is that 80 continuous days the woman should have worked. By continuous, don't think that if they take a leave in between, it will not be covered. If you remember a standing orders act discussion, would have clearly said how dates are calculated. So if you have taken sick leave, allocated leave, and all is continuous employment only. Just that there should not be break in service. And how was service period calculated also we have seen while calculating gratuity act. Well, gratuity under gratuity act. So 80 continuous days work should be there. Now exception is that this 80 days is not applicable in case of a woman who has immigrated to the state of Assam and was pregnant at the time of immigration. For those women, this 80 days criteria is not applicable. And also, if a woman is covered under Employee State Insurance Act, they will also not be covered under MB Act. And I think it's clear by now that all categories of employees, including the set out below, are eligible for maternity benefit, like daily wages, daily wage workers, contractual workers. All category of employees are covered under MB Act. Now the biggest benefit and the most popular benefit of MB Act or Maternity Benefit Act is the maternity leave. So a woman shall be entitled to 26 weeks of maternity leave, out of which not more than 8 weeks shall precede the date of her expected delivery. So they can go for 26 weeks of maternity leave, which roughly counts up to 6 months. And in that 8 weeks, which roughly counts up to 2 months, has to be, so the maximum has to be maximum time before delivery can only be 2 weeks. So it's not like you spend 5 months before delivery calling it a maternity leave and only just 1 month after delivery. So you cannot plan it that way. Maximum you can take us 8 weeks before expected date of delivery. Now there is this interesting case of K. Umadevi versus the government of Tamil Nadu. What happened here was Umadevi was a teacher in a government school, and before joining the government service she was married and had 2 children from the above said marriage. Now in 2017 the petitioner and her husband were legally separated, and the 2 children born out of the wedlock were in the custody of the former husband. She then remarried and have conceived another child. Going forward, you will see that this 26 weeks of maternity benefit is reserved for first 2 children. Now this, by the count of her children, is the 3rd child. So she conceived another child, and the question before the court was that whether the petitioner is eligible for grant of maternity leave for the third child on account of her marriage. The court allowed the petitioner maternity benefit of 26 weeks despite having two surviving children from the first wedlock. So the court observed that the expression used in the section 553 of MB Act prescribes a maximum period of entitlement of maternity benefit for a woman having two or more surviving children. So court interprets surviving children as children whose already is still in the custody of the mother. And here the court observed that since the two children are not with the child, it cannot be construed as having two surviving children at all. Hence the court said that she has to be given 26-week maternity leave. There are also other benefits. For example, leave for miscarriage. If you provide proof as per the prescribed medical reports and all, a leave with wage at the rate of maternity benefit for a period of 6 weeks immediately following the day of miscarriage will be given. The act also ensures post miscarriage 6 weeks leave. That's what I said. A lot of people think maternity benefit is just to provide once after delivery there is a few weeks of leave. That's just the maternity benefit act. No, you have gone through a miscarriage, there is a provision to give you leave. If you had a medical termination of pregnancy, again 6 weeks immediately following the day of medical termination, provided you give the proof. Leave for tubectomy operation. So if you have undergone a tubectomy operation to ensure that no more children will happen, a period of 2 weeks is the you are entitled for 2 weeks of leave. There is also provision for surrogacy leave. A commissioning mother, if we have defined what is a commissioning mother, whose egg is used for an embryo, though she is not carrying the baby herself. So a commissioning mother shall be entitled to maternity benefit for a period of 12 weeks from the child is handed over to her. Now, I am making a strong case of utilizing various benefits under this MB Act, but one problem is that for you to prove all this, a miscarriage, medical termination of pregnancy and all, you need to provide proof and then you have to communicate to the HR, and often these topics are still a taboo in the country. And often a woman, I've seen women who decides I'll take a normal 2-3 days of leave and then a weekend, that's good enough for me. Let me not utilize the provisions in the act. I'll rather keep this a secret. So that is still a big issue, but it's for your awareness that there are these provisions which you can exercise if you ever come across through these situations. Now there's an interesting case of Rama Pandey versus Union of India. The question before the court was that whether a female employee is entitled to maternity and child leave in case of surrogacy. So the court opined that the concept of maternity extends to the commissioning mother in the event of surrogacy arrangement and when she remains the legal mother of the child. The court recognized that denying maternity leave due to lack of biological pregnancy would not be in the child's best interest. And it's a constitutional position that a welfare state should be looking at the best interest of the child. So, provisions for leaves for even surrogate mother or rather commissioning mother is also available. There is also adoption leaves available. A woman who legally adopts a child below the age of 3 months shall be entitled to maternity benefit for a period of 12 weeks from the date the child is handed over to her. Now there is this argument ki is 12 weeks enough to take care? And what is this logic of age of 3 months and below? What if the child is 4 months? It needs as much as care. So, which is a valid argument, and it is still pending in the Supreme Court. And some of the remarks that has been made by the Supreme Court is towards the direction that the court also feels key. This 3 months cutoff doesn't make a sense, but the verdict is still not out. Probably in due course, see, a welfare state always works towards better and better welfare mechanisms. So I'm sure sooner or later there would be a verdict, a judicial interpretation that might or will extend this bottleneck. Now imagine you are suffering from an illness arising out of pregnancy or delivery or a premature birth of a child, a miscarriage or medical termination of pregnancy or tubectomy. So if you produce such proof saying my illness is arising out of these complications, this MB Act, there is a provision for you to take a leave of up to 1 month with wage. Wage is as defined by the Maternity Benefit Act. There is also provision for medical bonus. So a woman who is entitled to maternity benefit under MB Act shall also be entitled to receive from her employer a medical bonus of 2,000 to 3,500, 2,500 to 3,500. So that provision is also there. Another provision is nursing break. So every woman who returns to the duty after delivery of the child shall be allowed in the course of her daily hours 2 breaks of prescribed duration for nursing the child until the child attains the age of 15 months, which is 1.5 years, in addition to the interval for rest allowed to her. So let's say she is a factory worker, lunch break is only from 1 to 1:30 or 1 to 2. Above it, the law says that she should be allowed 2 more breaks to nurse the child. You might be thinking, where is the child coming here? She is at her workplace. This act also says that an establishment which has 50 or more employees, and it doesn't say only women employee, 50 or more employees should have a creche facility within such distance as may prescribed, either separately or along with common facilities. So the act clearly says if you have more than 50 employees, you need to have a creche. So this nursing creche is where the children are taken care of. So you give the child there. There is a caretaker who will ensure that the child is taken care of. So the act says that there should be a creche, and the mother should be given 2 nursing breaks to go and check on her kid. Over and above, a woman shall also be allowed 4 visits a day to the creche, which also include the interval for rest allowed to her. So in the rest time she can go 1 or twice. There are 2 allowable nursing breaks for her. That is also there. So 4 visits shall be allowed. What about work from home for a woman who is completed her maternity leave? So the position of the act is that, or a judicial position also is that, where the nature of the work assigned to the woman is of such nature that she may work from home, the employer may allow her to do so. Do so after the maternity leave is over, provided the conditions are agreed by the employer and the woman. The whole idea is that if the job is of a kind where it can be done from the home, this act increasingly promotes this idea that the work from home facility should be given to the woman, And of course, if there's some arrangement that has to be made in terms of maybe once a week you have to come and show the or, whatever progress has been made, or there should be a check-in time starting from 10 o'clock to evening 6:30. Those conditions the employer can keep. An interesting case is the case of Prachi Sen versus Ministry of Defense, Government of India. So the petitioner was the senior executive engineer at Stark, and she said that she should be allowed to carry her work from home after her maternity leave is over under the Maternity Benefit Act, because the Act clearly talks about giving a provision for work from home. So the court said that work from home post maternity leave can be authorized only if the nature of the work entrusted to the employee permits it. So the employer has to say, or the court has to feel that the nature of the job the woman is doing is something that can be done from the home. And in the particular case, the petitioner's job was to do certain sensitive research, which needs a lot of privacy, and it's very important to state security also, and hence it could not be done from home. So no relief was provided with respect to continuing work from home. If you remember our discussions, the latest news regarding labor laws is that 29 labor laws has been consolidated into 4 labor codes, and the Maternity Benefit Act is now subsumed under the Code on Social Security. So this code provides that the central government may frame and notify from time to time suitable social security schemes on matters including maternity benefits for gig workers and platform workers. So existing law does not cover gig workers or platform workers, but the newer position under labor code is that these benefits should be extended to gig workers and platform workers also. Also, this code have enhanced the penalty rates also in case if an employer violates the provisions in the act. So with that, let me conclude today's session. If you remember what we have done today, we have gone through the Maternity Benefit Act. We first looked at its historical evolution starting from a Bombay Legislative Assembly to today's Social Security Code. After that, we looked at various definitions under the Act. What is a commissioning mother, who is a woman, and how is wage defined in this Act. After that, we looked at the applicability of Act, in which all institutions, in which all establishments this Act is applied. Then we looked at the eligibility under this Act, who all can, who all are eligible under this Act for the various benefits provided by this Act. After that, we looked at the exhaustive list of benefits this Act ensures to the woman who is covered under this Act. And finally, and the benefit includes maternity leave, it includes crush facilities, it includes breaks to nurse the child, it includes tubectomy leaves, it includes adoption leaves, it includes commissioning leaves, medical termination of pregnancy leaves, miscarriage leave. All those things are we discussed in detail. And then finally we looked at how or what is the newer position in the Social Security Code when it comes to the maternity benefits. So with that knowledge, let's conclude today's session. In the next class, we would be discussing about the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, popularly known as the POSH Act. So we look at various provisions of POSH Act. It's a very comprehensive act which looks at defining sexual harassment at workplace and also brings in certain mechanisms to ensure that all sorts of harassment, especially sexual harassment, is prevented, prohibited, and in case such an act happens, how redressal can be achieved or can be taken care of. So this act is a comprehensive act. We'll discuss this act in detail in our next session. So until next session, let me take a break. You have a great day ahead. Thank you so much.